Dear guest, my name is Roman. I work as a project coordinator at Center for Civil Liberties. It is Kyiv-based think tank. And together with our partner, Abaroli, American Bar Association Rule of Law Project, we conduct a joint activity in Ukraine, a project named Promoting Internet Freedom in Ukraine. The project itself entails various activities, including educational one. And today, we have a webinar which is a part of so-called Internet Freedom Club. It is a series of webinars on the subject of media law, IP law, ICT law, and other related topics. Our webinars are available on our YouTube channel, and I will share the link with you in the chat. I will be your moderator today, and feel free to to write your question in chat below. Today, our speaker, Oleg Soldatov, will speak about freedom of expression online, case law of European Court of Human Rights. And we believe that Oleg is an ideal person to give such talk, precisely because of his previous educational and professional experiences. Oleg worked as a legal advisor currently in Council of Europe in Strasbourg, and previously he was working as a registry lawyer at the European Court of Human Rights itself. His previous educational experiences include LLM from Ghent University in Belgium, Masters of Management from Stockholm School of Economics, and PhD degree in Legal Studies from Milano Bocconi University. And given the fact of his professional experiences both in court registry and in Council of Europe, which is more politically policy-driven domain of work, we're happy to have Oleg today with us. Oleg, the floor is yours. Please feel free to share your presentation. We're going on. Thank you.
Thank you, Roman, for your introduction. Can you please confirm that you see my screen?
Not yet. Not yet.
Well, you should be able to, because I've just shared it. Okay, let's.
Yes, we see. Thank you.
Okay, so let's do the. I presume you now see only one slide.
Yes.
Yeah, freedom of expression online. Perfect. And if I click, then I'm moving between the slides.
Yes, indeed.
That is great. So once again, Roman, thank you for your introduction. Thank you to the Center for Civil Liberties in Kiev, and thank you for the American Bar Association Rule of Law Initiative for inviting me to speak. I also understand that the majority of you are joining me here from Kiev, Ukraine, or from other cities of Ukraine. Well, I'm Ukrainian myself, and it's great that lawyers at such a, let's say, hard time still find time to work on their skills. Let's hope for the best for Ukraine in the next days, and let's hope that this horrible war that Russia started will be over soon. I'm here on the tangentially connected topic. I will speak about the freedom of expression online through the lens of the European Court of Human Rights. And frankly, Roman already introduced me very aptly. When I started my law career back in Ukraine, I got a degree from the Kiev Mohila Academy. I thought that my legal career would be really straightforward, but in the end, it ended more like a roller coaster. Over the last 15 years, I have worked in 9 different countries. And right now, as Roman already mentioned, I am a legal advisor at the Council of Europe headquarters in Strasbourg. I have to give a necessary disclaimer that the opinions expressed in this presentation are my own. They do not necessarily represent the views of the Council of Europe, although, of course, I do my best to give you the gist of the both legislative and case law perspectives of our organization. Without further ado, I will now present the organization to you, and our presentation will be structured in roughly 3 big parts. Firstly, I'll speak about the context. What is the Council of Europe? What is the European Court of Human Rights? How does the court work? Then I will speak about freedom of expression in general and online in particular. And to preempt some of your questions, in the last part of the presentation, I will cover what the future may hold. How will the legislation move forward? How can the case law of the European Court of Human Rights move forward in future? Because there are a lot of things that are still undergoing the process of being transcribed into legal norms. So to begin the introductory part, the Council of Europe is an organization that was set up to promote democracy and protect human rights and rule of law in Europe. It was founded in 1949. And you may immediately say that the map on the left side of the slide is wrong because it includes Russian Federation, which has been excluded from our organization in March, and it will completely cease its membership by September this year. So our new visual identity already does not include Russian Federation, and it talks only about 46 member states instead of 47, which was the case still in the beginning of March of this year. All of us, of course, know the reasons for exclusion of Russian Federation from our organization. Please do not do not make this confusion between the Council of Europe and the European Union. Council of Europe is an independent organization which cooperates with the European Union, but it's still a wider organization, and our views on how human rights should work do not necessarily align with the views of the European Union, but of course, mostly they do. So again, we are not an institution of the EU. We should not be equated to the Council of the European Union, which is a body that has all the government ministers from the EU countries, and it should not be also confused with European Council, which consists of heads of state and ex officio members from the EU countries. Now, every EU country is in the Council of Europe, but then we have some extra countries like the UK or like Turkey, which are not inside the European Union, but they are in the Council of Europe. The European Union right now covers around 447 million people, while the Council of Europe is much wider, and the number of people living on the territories under its jurisdiction is about 700 million. Our main instrument is the European Convention on Human Rights, which was drafted in the beginning of the 50s, entered into force in 1953. It is also the basis of the operation for the European Court of Human Rights. And there is this truism that convention is a living instrument, which means that convention itself, it's a rather small brochure. And of course, you cannot explain all the intricacies of how human rights should work in a short legislative instrument. So we have our European Court of Human Rights, our highest judicial body, which through its case law explains how the convention should be applied. Again, please do not confuse the European Convention on Human Rights with the Universal Declaration, which is the United Nations instrument, and with the Charter of Fundamental Rights of the European Union. Now, I won't speak too much about how the Council works. I will only say that, well, of course, we do have the court, which delivers judgments on human rights related issues, but we also work in this sort of strategic triangle of setting standards via our conventions, of monitoring via our monitoring bodies, and of technical cooperation, which are our projects in the countries where we are present. Now, let's move to more legal stuff. The European Court. All of you know that it's based in Strasbourg. It has 47 judges by the number of member states. Please, again, the last possible confusion, do not confuse the European Court of Human Rights with the International Court of Justice, which is the United Nations body in The Hague, and with the Court of Justice of the European Union. Today, mostly, I will be speaking about the case law of the European Court of Human Rights, although in the last part of the presentation, when I'm talking about what the future holds for us, I will speak a bit about the Court of Justice of the European Union and its judgments on the subjects that are relevant to our topic. So one of the important things is to remember that the jurisdiction of the European Court of Human Rights is rather limited. It only looks at the applications lodged against member states. So, you know, in the legal tradition in English language, you always see the name of the case as being one party versus another party. So this second party, respondent party, whenever you're looking at any case before the European Court of Human Rights, it would always be one or more of member states of the Council of Europe. So it will always be someone versus Ukraine, someone versus the United Kingdom, someone versus Switzerland. It will never be an individual or a private institution. That is the biggest thing that you have to take away about the jurisdiction. Again, another thing is that the acts or omissions must be attributed to public authorities, and they must pertain to the rights protected by the European Convention. And of course, applicants must have used all the remedies in the state concerned, which means that basically, if we're talking about Ukraine, before going to the European Court of Human Rights with an alleged violation of the member state of Ukraine of the European Convention, you should first go to your local court, then you should go to your court of appeal, and then you should go to either the Supreme or a Supreme specialized court, depending on the jurisdiction locally in Ukraine. And only then, after going through these 3 levels of jurisdiction in Ukraine, for the majority of cases at least, you can go to the European Court of Human Rights and lodge an application before it. So you don't have that much time in terms of lodging your application. From the date of the final domestic decision, you have to go to the court within 4 months. It is a very recent change by the latest protocol to the convention. There is this common saying that the Court of Human Rights is not a 4th instance court. Although you go through 3 levels in the beginning, then the Court of Human Rights, it doesn't act as a 4th instance, so to speak. It only looks at how the convention was applied by state authorities, including state courts, in a certain case. And of course, there is this margin of appreciation doctrine, which is a concept of its own, which basically means that the states, when they decide how to implement human rights provisions of the European Convention on Human Rights, they still have a bit of a wiggle room, so to speak. They don't necessarily have to apply everything in an absolutely uniform way, because of course, every country, every member state of the Council of Europe has its own culture, has its own context based on its history, has its own legislation. So there is sort of this margin of appreciation. If you're interested, you should definitely read up on this concept. I would also say that 90% of cases that come before the European Court of Human Rights are inadmissible, which means that they do not even get to the point where they are judged on the merits. Basically, the court says, you've made a procedural mistake, will not look at your case. So I presume that some of you will eventually represent clients before the European Court of Human Rights, and I trust you that you would make sure that all of the procedural norms are complied with before you lodge an application before the court. Last but not least, the court has this special instrument envisaged by Rule 39 of the rules of the court, which is called interim measures. So we know that the parties have to, the applicant has to go through all the levels of protection is in his or her country before he or she lodges the complaint before the court, the application before the court. But sometimes when we're speaking about the right to life, for instance, it's not really realistic to wait for a person who is right now at present dying from internal bleeding in the prison to go through all the levels. At the same time, again, a person who is right now at the aircraft, which is about to take off and to take this person to a country where his or her rights will definitely be violated, let's say Russia, it's unlikely that this person has time to go through all the levels of jurisdiction, which means that there is this special procedure called an interim measures procedure, where the court, even without the person having exhausted all the national remedies, instructs the respondent country to do something immediately to make sure that the person basically survives and doesn't suffer some irreparable damage while his or her case is being looked at by the national authorities. So if we talk about the person with internal bleeding, for instance, the court could say, please immediately transfer this person from prison to a hospital with qualified doctors where the person's condition would be treated. If we are talking about deportation to the country like Russia, the court can say, please stop the plane right now, take this person off a plane, put him or her in, let's say, detention, but make sure that he or she is not departed to the country where he or she will face grave danger. So this is a little bit of the context. Let's now move on to the actual Article 10, which deals with freedom of expression. And I presume that for some of you, it is immediately a question, why are we speaking about freedom of expression instead of freedom of speech? I know that this event is sponsored by American Bar Association, and all of you perhaps know that in the First Amendment to the US Constitution, the term used is freedom of speech. And this has proven to be a bit of a nightmare for American legal scholars, because, you know, the very first definition of speech, when we hear the word speech, we think about the person using his or her mouth to impart certain information. While, of course, in the 21st century, speech is not just something that you say. Speech may be something that, you know, you write, but okay, that is easy. Speech may be something that you have tattooed on your body. Speech may be something that you do while you are silently protesting in front of a state institution. So even silence can be speech. So to avoid all of this legal hassles, while drafting the convention here in Europe, it was decided to use a wider term than speech. Hence, we have the current wording, which is everyone has the right to freedom of expression, which includes freedom to hold opinions, receive and impart information, and we have seen the first part of the article. We should always remember that this is not about just the right to impart information. It's also about the right to receive information. So it's about access to information as much as the right to impart information. Of course, every right has its own limitations. And the second part of the article deals with those limitations on the freedom of expression. The second part of the article says that the exercise of these freedoms may be subject to formalities, conditions, restrictions, or penalties as are prescribed by law and necessary in a democratic society. So let's think, what could be conditions and restrictions? Usually this is the part of this lecture where I give floor to my students, but since we don't have that much time, I'll give you the answer immediately. There is an exhaustive list: national security, territorial integrity, public safety. First reason. prevention of disorder or crime, protection of health or morals, protection of reputation or rights of others, preventing the disclosure of information received in confidence, maintaining the authority and impartiality of the judiciary. Once again, this list is exhaustive. You cannot just come up with some other reason. And Roman has kindly shared with me some questions that some of you preliminarily sent in before this event. And you asked, how does the court analyze in each case whether there is interference with freedom of expression? Basically, the court applies tripartite test, which is not only applicable to Article 10, it's also applicable to Articles 8, 9, and 11. So we're also talking about, private life. We're also talking about freedom of assembly. We're also talking about religious rights. In any event, this tripartite test is really simple and is applied every time the court has to look at restrictions on freedom of expression. The interference has to be necessary in democratic society, has to be prescribed by law, and has to have a legitimate aim. So the first two, of course, the very first one, this is a rather subjective thing, but if you look at the case law of the court goes about it on a case-by-case basis. The second one, be prescribed by law, that is rather simple. If you have a piece of legislation that talks about this, then we can say that a certain interference is prescribed by law. And the third one has a legitimate aim. Basically, if we return back to the previous slide, here is this exhaustive list of legitimate aims that can, but not necessarily will, allow the state authority to interfere with the right to freedom of expression. Again, one of the things that you asked is, what about interferences in the time of war, such as what we have been facing in Ukraine, to the certain extent, from 2014, from the annexation of Crimea, from the events in Donbass. And you can immediately see that there are restrictions here that are directly connected to what is happening at the time of war. National security, territorial integrity, public safety, prevention of crime, and to a certain extent, prevention of disclosure of information received in confidence, because when we're talking about, military secrets, for instance, it's not just national security, it's also certain confidential information. The court, as I've said, is always expanding its views on how this or that article of the convention should be read. And since convention is a living instrument, as I've said, the court has already set out certain themes that broadly have special protection under Article 10. Those are issues that deal with matters of public interest. Those deal with media, because the court said that media is a watchdog in terms of expression and in terms of, the information imparted and received on the territory of a certain state. Access to information held by public bodies also is a very special case, because public bodies should be transparent, but at the same time, there are certain things that cannot be just made public. Protection of journalistic sources, protection of media diversity, and protection of those who are at risk of physical or other attacks from exercising their freedom of expression. Again, we are speaking about freedom of expression online here, so I will not be able to speak too much about, freedom of expression in the context of military conflicts or on the matters of national security. For those of you who would like to read up on this a bit more, please flash right now this QR code. This is a very good and rather recent guide, and there is a short chapter there that deals with matters of national security and with freedom of expression in military contexts. It's a free PDF distributed by the Council of Europe. So Since this is a little bit outside the scope of our lecture, please flash the QR code and read this guide for this exact questions. Now, of course, when we are talking about internet in general, we're not only talking about Article 10, which protects freedom of expression. There is always this balance that we have to find. For instance, when I'm speaking about someone, I am not just imparting information. I might also interfere with the right of this other person to respect for his or her private life. And there is a long list of things that have to be weighted. The questions of personal data protection, and I presume that among you there is definitely one or two GDPR specialists, because Ukraine is slowly moving towards GDPR standards in terms of personal data protection. There are also questions of privacy of electronic communication. There is also questions of privacy of access to the internet and of net neutrality. And we will speak about this a bit later. Then, of course, it's not just private life, it's also property. And it's rather simple how protection of property under Article 1 of Protocol number 1 has to be weighed with freedom of expression. In this lecture, you see that I'm always attributing images, for instance. So any image that I'm using is under the Creative Commons or other similar license, because property is not just something physical. Property is also intellectual property. Things like photos, things like movies, things like music, all of that is protected by Article 1 of Protocol number 1. And basically, if you look at the French text of the Protocol 1, it talks about something much wider than property in its French version. It talks about biens. And for French readers of the French-speaking readers of the convention, it's much easier to understand that biens is something really wide, which definitely includes such things as intellectual property. Now, of course, then there is right to education and basically not to be indoctrinized. And then there is right to free elections. And last but not least, there are these specific articles, Article 13 and Article 14 in Convention. The violations of these articles always occur in parallel with violations of other articles. Those are Articles 13 and 14. Article 13, right to an effective remedy in a certain situation. Basically, the state has to make sure that you always have an effective remedy in your jurisdiction whenever it comes to violations of your other rights in the convention. And then, of course, Article 14 is prohibition of discrimination. Again, the state has to arrange its legislative framework in the way that the exercise of any of the rights enshrined in the convention is not in any way discriminatory, so that you are not discriminated when you're exercising certain rights. Let's jump to the online context in a broad sense. Our current president of the court, Judge Spano, speaks about 4 main things that make online communication unique. There is a rich variety of content which is immediately available. There is minimal cost of access to the internet. There are virtually no barriers to communication, and there are equal opportunities. We will revisit this statement later, closer to the end of our lecture. But more or less, this is how internet has been working in the 90s and in the beginning of 2000s. There is a big question what the internet actually is and who runs it. And we should, of course, be aware of all the different levels of internet governance framework. We have end users, all of us, every one of us, whenever we write an email or share a blog post or post something on a forum, we create internet bit by bit. Then, of course, there are intermediary platforms and services such as Facebook, Instagram, Twitter. They give us this broader sort of platform like frameworks for participation. Then there are international internet service providers such as Vodafone or Kyivstar or Vola Cable in Ukraine. Those are the providers that deal with getting the internet from big exchange points to your homes via cables, or lately, as is case with Elon Musk's initiative, via satellites. And then, of course, there is big telecom and government-owned cable infrastructure that is organized by these huge corporations and by governments who run underwater cables on the beds of the oceans. And there are separate conventions on that. And then, of course, there are all the protocols. So I won't go into technical details, but there are many, many levels of complexity when one tries to say, to define what the internet is. And with such a multi-layered definition, of course, there are very diverging approaches to online regulation. There is this absolute or libertarian approach. The proponent of this libertarian approach, the perhaps most famous one, is Timothy May, who first wrote in 1988 and then updated several times his document called Crypto-Anarchist Manifesto. So the view of libertarians is that the information community is something unique or sui generis. It's a wholly novel medium which should not be regulated at all. And the second approach is the social responsibility approach. And we can see that now the countries, as well as the courts, including the European Court of Human Rights, they tend to take this second approach, the social responsibility approach to online regulation. The biggest idea here is that duties and responsibilities are the same offline and online, and thus the same legal principles apply. Harvard professor Dr. Goldsmith in 1998, in his Against Cyber Anarchy essay, which was in many ways a response to this Crypto-Anarchist Manifesto, said that both cyberspace and ordinary transaction involve people in real space transaction with other people in real space, and their transactions can sometimes cause real world harms. So the big issue is right now no longer whether it's possible to regulate the internet. It's about how to do this, how to regulate it. So with this, I presume I gave you a little bit of context. And now let's jump right into the second biggest part of the presentation. How does the European Court of Human Rights adjudicate on disputes involving internet and involving expression? Of course, one of the things would be for the court to decide whether it has jurisdiction over a certain matter. Roman, can you please confirm that you can still follow me, hear me, that there are no technical issues?
Yes, all correct. Thank you.
Okay, perfect. Thanks. So this is a rather old case by now, 17 years old, and it dealt with publication of obscene materials online, basically publication of porn by a French national living in the United Kingdom, and he was reposting content from the United States website, which this content was fully legal under the United States law, but under the United Kingdom Decency Act, actually from 19th century, if I'm not mistaken, it was proscribed. So the UK Court of Appeal considered that UK courts had jurisdiction over this matter, even though the national was in a different country and the content originated in a third country, which was not even in Europe. And here the European Court of Human Rights accepted this approach. Basically, what is the main idea here is that it doesn't matter where the content originates from. What matters in terms of defining the jurisdiction of the European Court of Human Rights and, well, by extension of the national courts, is where are the people who are consuming certain content. And here again, we return to this problematic of margin of appreciation, where the material might have been legal in some states, but the UK didn't exceed its margin of appreciation by proscribing certain materials because they were obscene. So having dealt with jurisdiction issues, another big question is whether a certain person, when he or she is proscribed by reaching certain content online, can be considered a victim for the purposes of applying Article 10 of the European Convention. Let's say if I cannot reach a certain website because my state authority blocks it, like Vkontakte is being blocked in Ukraine or Facebook is being blocked in Russia. Am I a right person to go through all the levels of jurisdiction in my own country and then eventually to go to the European Court of Human Rights to try to protect my right? And here we have several cases from Turkey. And they're all, well, not all of them, but many of them deal with a certain historic personality. Their first president, Atatürk. So in this case of Agdeniz versus Turkey, an applicant here managed a small website which was hosted on a much bigger platform called Google Sites. You may know that right now, of course, there are bigger alternatives to Google Sites. If you want to create a platform, if you want to create a site online, you would use maybe WordPress, or you would maybe host it on Wix or someplace else. But Google Sites, let's say it was popular 10, 12 years ago. So Google Sites allowed tens of thousands, hundreds of thousands, millions of users to create a small website under their, general umbrella on the Google Sites platform. And in 2009, the local court in Turkey ordered to block access to another site hosted on Google Sites, which was insulting the memory of this Turkish hero, President Atatürk. Yildirim's site was a different site hosted on the platform, but the whole platform, sites.google.com, was blocked entirely. And eventually, of course, not a single Turkish citizen could use this platform. The applicant came all the way to the European Court of Human Rights, and the court said that this order to block the whole platform in its entirety amounted to a violation of the right to freedom of expression, because the restriction must be prescribed by law, which means that it must be formulated with sufficient clarity. And then the law, of course, should not authorize wholesale blocking of entire platforms. There is no evidence that Google Sites here had been informed of hosting illegal content. The law confirmed extensive powers on administrative body, and there is this significant effect of collateral censorship. I believe I am misrepresenting the name of the case. It should be Yildirim versus Turkey, because the next case is the one that is involving Agdeniz. My apologies, so please scratch this name in your notes and put this name. Yeah, a short technical mishap. Let's look at a different case then. Also Turkey, but here it didn't have to deal with insulting a memory of a national leader. It was rather about blocking access to a certain musical platform, MySpace. Remember, we spoke about weighing, balancing different human rights protected by the convention. Here, the right that had to be balanced was the right to property, because big musical platforms, MySpace and Last.fm, maybe some of you who are more or less my age would remember MySpace. It was a platform popular in 2008, before Facebook became a thing, where everyone could upload music. So the whole platforms were blocked again, but because of the breach of copyright. The applicant appealed against this decision and lost. And here, In contrast to the personal case, Yildirim, the applicant did not enjoy victim status because he was only deprived of the one means of listening to music among many others, and he could not say that he couldn't express his rights online because certain platforms where music was disseminated were blocked. Let's see whether this would also apply to YouTube. There was one more case, Sendis versus Turkey, which dealt with complete block of YouTube. Once again, you know YouTube, it's a huge platform, millions of, well, probably billions of videos, and millions are added every day. And the whole platform was blocked in Turkey based on 10 videos on it that insulted the memory of Atatürk. The applicants were a group of professors in the university who needed to use YouTube for educational purposes. And they also uploaded their academic work there. And well, they were indirectly affected by this ban of YouTube. They couldn't interact with their students and they couldn't lecture in the way they lectured before because of this ban on the whole YouTube as a platform. Here, the court said that there was a violation of Article 10 because, well, even right now in 2022, there are no viable alternatives to YouTube. And back then, it was basically the most popular platform for political discourse, which displayed specific information that could not easily be accessed by other means. So let's compare this to this Agdenis case, where MySpace was just one of the platforms of listening to online music. Here we're speaking about more or less the only means to access certain information online. Then last but not least, we have the Roskomnadzor cases. And oh yeah, this is a slide which is from my presentation in Russian for Russian lawyers back when Russia was still party to the European Convention and to the Council of Europe. So my apologies for a couple of words in Russian up there. You know that they have their own authority called Roskomnadzor. You know, back in 2021 in Greece, when I was presenting this, I said that, look, these are our first Roskomnadzor cases. We don't know how the situation in Russia will evolve, but probably there will be much more Roskomnadzor cases in future. And those cases were very similar to previous Turkish cases. They dealt with collateral blocking, excessive blocking, and wholesale blocking. And here in those cases, the court held that there had been a violation of Article 10 and Article 13 in conjunction with Article 10, because it underlined the importance of internet as a tool for exercising the freedom of expression, and it criticized the Russia's Information Act on a similar grounds that it criticized the Turkish legislation because the Russian legislation produced excessive and arbitrary effects and had not provided proper safeguards against abuse. So once again, here when the court was looking at this block, it looked at three specific things: whether there were collateral effects, whether blocking could be excessive, and whether blocking could be seen as wholesale. I, by the way, know that there are in Ukraine currently some pending cases on the Vkontakte block. I presume that right now it's not very high on the agenda of our judges with all the stuff that is happening in Ukraine. But eventually, I guess Vkontakte may also reach, Vkontakte cases may also reach the European Court of Human Rights. And it would be extremely interesting to see what the European Court of Human Rights will say, because we do have in Ukraine a wide ban on certain platforms, but in view of what has been happening since 2014, of course, there might be ways to say that these restrictions, since they deal with national security, territorial integrity, they are well-founded. So we'll see. I have no clue whether at any point we'll have a case like this and whether it will be adjudicated, but it would be rather interesting to see what transpires. So let's look at freedom of expression in commercial context. Here, a landmark case is Ashby Donald versus France. So here the applicants basically went to the fashion show, took some pictures, published them online, and started taking money for from users who downloaded those fashion pictures. Here, first question was, again, whether there was an interference by the state when the national courts found these photographers guilty of copyright infringement. And I'm not giving you all the details, of course, of the case. Feel free to read up on it. But the basic idea was that they were photographing the fashion show, and they didn't have contractual arrangements to allow for this photography to happen. So the court said that indeed, by finding the applicants guilty of copyright infringement, France did interfere with their right. But at the same time, it did not violate Article 10, because there is a difference between, expression or content contributing to an issue of public debate. For instance, when we're talking about, bans on YouTube or bans on Twitter, or on the other hand, a debate on the other hand, commercial speech. These are not the same things, and they do not have the same level of protection when we are balancing Article 10 and copyright protected under Article 1 of Protocol 1 under the protection of property. So here, the court said that speech, messages, pictures, content, which are merely money-driven, do not enjoy the added value of the protection guaranteed by Article 10. So here, we should remember that there is always this distinction. Not every type of speech is created equal. Now, many of you may have heard about this concept of the right to be forgotten in the context of a different case, in the context of a case of a different court, the Luxembourg court, Google versus Spain. I am not talking right now at this point about the Luxembourg court. I'm talking about the European Court of Human Rights. We have our own take, and we have our own view on the right to be forgotten. If you remember the context in general, what is the right to be forgotten? It's this new concept that means that at some point, if certain information about you appears on the internet and portrays you in a certain way, when your life situation has changed and this information is no longer applicable, you have the right to ask search engines or to ask other relevant websites to delete this information, either from the results of the search queries or from their online repositories. Because, if in 2000 you did something, you don't want to be remembered for your whole life with reference to that fact. So this is an exactly similar situation. In 1993, these German applicants were sentenced to imprisonment for the murder of a well-known actor. In 2007, they had to be released after serving their prison sentence. They brought proceedings against media organizations which still had the articles about that murder on their web pages. And eventually the proceedings reached the European Court of Human Rights. And here the conclusion of the European Court of Human Rights is a bit different from the conclusion of the Court of Justice of the European Union in the Google versus Spain. The applicants' rights under Article 8 right to private life, had to be seen in the light of interests of society under Article 10, right to freedom of expression. Since there was an ongoing public interest in the events that occurred in the past, and which basically dealt with the murder of this well-known actor, the refusal to anonymize the media reports did not infringe the individual's rights to privacy. So if you remember in Google versus Spain, the Luxembourg court, it reached a different opinion, but of course it was not on the murder case. In Google versus Spain, the gist of the case dealt with information about certain, basically about the credit rating or about unpaid loans of a person, and that information was popping up on the first line of the Google search. And there the court, the Luxembourg court said that, look, of course, everyone has the right to be forgotten in certain contexts, and this information should have been deleted by Google. So yeah, we'll explore this if we have time a bit further later today. But this is something new, something recent, and this shows the interplay between Article 10, freedom of expression, and Article 8, right to private life, whenever these rights sort of compete against each other. Next case, you might already know what I'll be speaking about by looking at the left side. It's a pirate flag. So quite a lot of you might know what a BitTorrent is, and this case deals with balancing of the copyrighted material and right to freedom of expression. So we're talking about pirated music, pirated movies, pirated books, and we're talking about the so-called Pirate Bay. It was a site on the internet with the main team behind it in Sweden. It was a site where you could see the links to torrent files, which allowed you to download copyrighted materials, not even from the website itself, but from all the users online that had these files on their computers. So this is how the protocol works. Whenever you want to pirate a movie via a BitTorrent program, you do not download it directly from one source on the internet. You usually get a link, and then having this link with a specific description of the file, you download it in parallel from different computers all across the world, basically from all the people who have pirated this movie before you. So this website, the Pirate Bay, it was the most popular at the moment collection of links on the internet, of BitTorrent links. And it didn't just ignore the claims of copyright owners. It's, first of all, indexed torrents for the ease of search, and it actually posted the letters that they were receiving from copyright holders and made public fun of it. So on the national level, back in Sweden, several companies in the entertainment business brought private civil claims within criminal proceedings against defendants. These two brothers, Ney and Sunde, that run the Pirate Bay website, and they demanded compensation. Eventually, compensation was granted, 5 million euros, no small change. And they were also sentenced to 10 and 8 months imprisonment for respective brothers. And the question was whether this is an approach which is too harsh, because those guys, they didn't even distribute the content themselves. They just made it easier for other people to pirate content. And the European Court of Human Rights upheld this approach. and said no, the sentences and the sanctions were not too harsh. The applicants failed to take any action to remove the torrent files. They were indifferent to the fact that the copyright protected works had been the subject of file sharing activities. So all fine here, right to protect your property prevails over the right to freedom of expression. Now we're moving to the most interesting part, I presume, of the second part of my lecture. We'll be talking about commentary on the internet. And the biggest case here is rather old by now, but there is quite a lot of follow-up after this case. And this one still set the biggest principles. It's the case called Delphi versus Estonia, and Delphi is one of the biggest news websites in the whole Baltics, not just in Estonia, but also in Latvia and Lithuania. It's basically something like Pravda.com.ua or like Correspondent.net in Ukraine. It has its own system of notice and takedown, where Delphi warns users that it has the right to remove certain comments and restrict authors' access to writing of comments. And also, there was this system where you could flag the comment that anyone basically could flag the comment that he or she thought to be inappropriate, and then moderators would look into it. This whole case originated with an article about this company called Sarema Leva Company. The article in question was named SLK, Sarema Leva Company, Destroyed Planned Ice Road. And it spoke about Mr. L, basically the face of the company, the face of the Sarema Leva Company. So the article in question alleged certain things. The first one was, as you know, Estonia is on the Baltic Sea, and the territory of Estonia also includes certain islands which are offshore. But since it's very, very cold in the Baltics during the winter, the whole sea is covered by ice. And normally, you can just walk or drive a car between the continental Estonia and those offshore islands where many people had their cabins, had their private homes. So the allegation made by journalists of Delphi was this, that the Sarema Leva Company, the ferry company, it used its own ships to intentionally break down these ice roads. Every ferry in the Baltics is, of course, also an icebreaker. And when those ferries captains were instructed to go in certain directions, they broke the ice roads, making it impossible to reach certain islands by car or by foot, which made it, of course, very profitable for the ferry company, because then the people who couldn't reach those islands by ice, they had to buy tickets from the ferry company to use their ships to be transported to the islands. So you see, there is this very cheeky idea of the company to make a bit more profit. And the article generated really angry comments. I won't even repeat some of them. You see that this was something amounting to perhaps hate speech and to incitements to violence. I know this was another question that Roman kindly forwarded to me about the difference between hate speech and something that is not hate speech. We'll see other examples. For now, look at these examples, keep them in mind. You're talking about something that involves knocking the bastard down once and for all, basically killing a person. Or, you know, defecating onto the person's face. Here, eventually, the comments, they stayed online for some time, then Delphi took them down, and L was awarded a small amount of damages. Delphi paid him 320 euro, not that much. The court said that Estonian authorities, by imposing this fine on Delphi, did not violate Article 10 because Delphi exercised control over the publication of comments. It basically made money of the comments because it integrated them into the news portal. And also it allowed the commenters to remain anonymous. Last but not least, those comments contained incitement to violence and hate speech. There was no realistic prospect of holding authors liable, and in the end, the sanction, 320 euros, was rather moderate. Well, when this case just got adjudicated and was made public, a lot of people thought that this is the end of the free internet, that now, to avoid fines, all of the online portals will start censoring speech commentary, will require everyone to use their real names when registering for purposes of commentary, and that this will be the end of the free internet as we know it. The reality is not as harsh. There were several other cases which have shown that there is always a line between things that can be seen as hate speech or incitement to violence and other things which are much lighter, and that, you know, online you only have to monitor for the most extreme forms of speech. One of the post-Delphi cases was MT and Index versus Hungary. Look at the example comments here. They don't really look like hate speech. They're more of a defamation variety. So, sly, rubbish, mug company, a rubbish real estate website, you know, go and shit like a hedgehog and spend all your money on your mother's tomb, blah, blah, blah. But nothing really saying that we will either kill this person or, you know, we will defecate on his face. Here, again, Hungary imposed certain fines on the websites where these comments were posted by anonymous commenters. The court, in contrast to Delphi, said Hungary violated Article 10 by imposing a fine on these websites because one thing is making a news site monitor for defamation, another is making it monitor for hate speech. So now we're talking about this graduated approach slowly. Now we're talking about the fact that websites have to monitor for certain speech, but not for everything. Let's look at another case. Sanchez versus France, really, really recent. And here a politician had his Facebook page. He did not promptly delete certain comments there. And the comments, look again at the examples. Muslim community are drug dealers and prostitutes. They reign supreme there. Scum who sell drugs all day long. They are responsible for throwing stones at white people's cars. So something already rather close to hate speech because we're speaking about nationalities of a certain community. Nationals of a certain community. We're talking about Muslims here. And here authorities convicted this applicant. And the court said that it was fine to convict him because the court basically is willing to approve sanctions on those associated with hate speech, even in the political context. Remember, in the beginning, we saw that political speech may have a higher level of protection. When we're talking about hate speech, this doesn't apply. But again, we're talking about this graduated, differentiated approach. And you see here, I had to give you the examples of comments in all of the cases to make sure that we look actually on the case-by-case basis or what was being said. Last but not least, there is also a very, very recent case. Oh, and I should note that the case of Sanchez versus France, barely a couple of months ago, it was referred to Grand Chamber of the European Court of Human Rights. So this judgment is not final. So last but not least, the standard Verlags Gesellschaft, I probably murdered this, MBH versus Austria case. I am not going into details, but I will just say that a big point here is that the court, for the first time, if I'm not mistaken, spoke about the fact that there is no absolute right to anonymity online. Anonymity is important, but it has to be balanced against other rights and interests. And from what I understand, this makes it rather apparent that Europe is slowly moving in a different direction from the United States, where anonymity online is still seen as a rather important factor. So you'll see that in future there will be probably follow-up cases, but this case already sets this precedent where the court said directly, black on white, there is no absolute right to anonymity online, which has to be balanced against other rights and interests. This concludes the second part. I believe we don't have that much time left. Roman, can you check how much time do you think I still have to sort of wrap up?
10, 15 minutes.
Okay, so the third part I will have to rush through. It talks about the questions which haven't been yet addressed in full by the courts, and it talks about, future prospects. I've only given you some piecemeal case law, but those are the main things that the court looks at. And I saw that one of the cases, or one of the questions that Roman received was how the EU regulates speech online. And I have to say that we're in a very, very interesting time right now, because we have a piece of legislation which has not yet been finalized. And we'll see how it will come into the legislative field, in which form. It's called the Digital Services Act proposal and Digital Markets Act. So those are two pieces of legislation. It will regulate all the levels of online intermediaries with different levels of scrutiny and different levels of obligations attached to them. Since we don't have that much time, I won't speak about the exact levels, and I won't speak about how this will work. But what we have to remember is that Digital Services Acts is a piece of legislation which will soon enter into force and which will soon regulate the internet in the EU. An interesting clause there is the so-called Good Samaritan clause. So remember, we spoke about those instances where the online platforms have to monitor for certain categories of expression. Here, the proposed Digital Services Acts, and again, I should make sure that you understand that this is just a draft law at this stage. It hasn't been yet voted. Last month, there was already a political consensus on how to move forward with this. So it will soon be voted and it will soon become a piece of European Union legislation, but it's still not. So with this in mind, in general, Good Samaritan laws, they offer protection to someone who attempts a person in distress. We have something similar in Ukraine, for instance. If you try to help a person who is bleeding on the street and you are not a doctor, normally you have a certain level of protection from the persecution if this person dies. You have to still act in good faith and try all your best, but since you're not a doctor, you might not be liable for the death of this person, at least on a full scale. Basically, Good Samaritan legislation means that some help is better than no help at all. And how does this apply to online intermediaries? It applies when we're speaking about content takedown. Basically, if YouTube shows that it's at least trying to remove illegal content in a proactive manner, then it will not be held liable for, you know, all the illegal content that is found on YouTube. YouTube already has huge teams of people who are monitoring for illegal content. But, you know, it would be completely unrealistic for YouTube to monitor by human, with human interaction, for every single video that is being uploaded to the platform, because of course every second there are thousands of hours of content being uploaded to YouTube. So this Good Samaritan clause in the proposed Digital Services Acts means that YouTube or a similar service have to at least show that they made good faith efforts to remove illegal content, and they are acting expeditiously to disable access to various categories of illegal content. But again, there is a lot of criticism. We still don't know how exactly this will work online, but we can see that in general, what we're dealing with is outsourcing of content moderation, outsourcing of taking this judgment of what is and what is not permissible is slowly being moved to platforms themselves. Instead of the state saying this, and this is illegal, of course, the definitions are still there, they're still provided by the state, but it will be the platforms themselves who will proactively monitor what is happening. If you are interested, look up this case, which was adjudicated by the Luxembourg court, not the Strasbourg court, the Luxembourg court, the Court of Justice of the European Union, Poland versus Parliament and the Council. It talks about this preventive control mechanisms. Look into it if you're interested. Another thing is the self-regulation framework. So we saw in Delphi case, there was the notice and takedown system. And basically an idea by many legislators right now is to let the gigantic social media platforms regulate themselves. All of us remember the block of Trump on Twitter. These things happen, and then they may eventually come to the courts. But we are dealing with a situation of basically private censorship. Sometimes platforms, without any judicial involvement, decide to block certain users. And when this is such a high-profile user as Donald Trump, of course, this becomes a matter of public scrutiny. We'll see how this develops. But eventually, it seems that with the Digital Services Act, at least some degree of proactivity is being expected from digital platforms like Facebook or YouTube. So indeed, private censorship as a collateral damage of this monitoring becomes rather inevitable. Last thing is the artificial intelligence assisted filtering. Since we do realize that it would be impossible to employ people for the review of every single second of uploaded content, more and more artificial intelligence is being used to make difference between legal and illegal content. And it's rather easy right now for artificial intelligence, for instance, to understand if the video contains pornographic materials. It might be much more difficult for artificial intelligence to understand that certain hateful speech or political incitement politically motivated incitement to violence is being disseminated. So our Council of Europe Parliamentary Assembly Standing Committee said that there is a need for a global regulatory framework for artificial intelligence. As well, this was supported by our Committee of Ministers, which supports elaboration of the legally binding instrument governing artificial intelligence, possibly even in the form of the convention. There are many problems with artificial intelligence filtering, including, you know, the problems with live streaming. But eventually, we should understand that we don't have enough people on this planet to monitor every single piece of content that is being uploaded. Last but not least, another idea which may be put in action in future is the creation of specially constituted internet courts. So this is Robert Spano, our president of the court, and I've already cited him back in the beginning. He supports this idea of special team of judges in every jurisdiction that would deal with deal not just on a normal basis, but very expediently with internet-related questions. But of course, this means that we'll need more and more lawyers specializing in these questions. In the very end, we are dealing with, in many ways, a race to the bottom. You know, certain websites are being blocked, certain means of communication are being blocked, but then users are finding new ways to go around those blocks. For instance, you know, we know that in the Russian Federation, Instagram has been blocked recently, but still thousands of high-profile users from Russia continue posting on Instagram using VPNs. And VPNs are just the tip of the iceberg when it comes to instruments that allow you to circumvent certain internet blocks. There is the relaying onion, Tor networks. There are mesh networks, which basically can create an alternative to internet using equipment that is available in any hardware store, well, in any information technology store. There are questions of law effectiveness of monitoring bits and bytes which are moving through cables by this deep packet inspection technology. There are unsuccessful attempts to block certain messengers such as Telegram in Russia. There are unsuccessful attempts to turn off the internet in general. For instance, what happened in Syria in 2015. There are at the same time certain things that are happening, and China were rather, the Chinese were rather lucky and were rather well organized in terms of creating their own version of internet behind the great Chinese firewall. And now if you are in China, you would see that on your phone, you would never have Google services. You would not be able to use the majority of messengers just because the whole country is behind a firewall, which brings us to the question of splinternet. We won't have one big internet in the near future. Russians will have their own internet, Chinese will have their own internet. And it means that this 4 characteristics of the internet that Judge Spano proposed back in 2012-13, they are no longer so universal. I won't go too much longer about the pre-moderation issues and self-regulation issues and preemptive anonymization issues. I would rather leave you maybe 5 minutes for extra questions. Before that, I will conclude on this metaphor that I really love, the Red Queen metaphor from the Lewis Carroll's Alice Through the Looking Glass. In this scene, you might remember that the cards and Alice are running very, very fast to reach a certain location. And in the end, Alice realizes that they're not moving, even though everyone is running fast. And Alice says, well, in our country, you generally get to somewhere if you run very fast for a long time, as we've been doing. And the Red Queen, another character in the Lewis Carroll's book, answers, a slow sort of country. Here you see, it takes all the running you can do to keep in the same place. If you want to get somewhere else, you must run at least twice as fast as that. This is called a Red Queen metaphor, and it's being used to describe, for instance, in biology, how parasites adapt to their hosts. let's take the example of fleas and dogs. You know, fleas suck the blood out of dogs. Dogs start growing longer fur. Fleas invent ways to dig deeper under the fur. Then humans domesticate dogs, invent certain chemicals to make sure that fleas are no longer there. Fleas mutate and become resistant to those chemicals. And we have this race where everyone is running as fast as possible, but in the end, the status quo is still the same. We are living in a very unique time when we can see that the same thing is happening with the internet. Certain countries try to control the internet, but then groups of people find ways to overcome those obstacles. At the same time, certain people try in many ways to abuse the internet, but the countries find ways to make those efforts not very effective. And when it comes to internet regulation, we are now in this race where everyone is moving as fast as possible, but we are not really moving anywhere yet. So we'll have a very nice couple of years before us with the introduction of the European Union Digital Services Act, with the new cases of the European Court of Human Rights, with maybe the new cases of the Court of Justice of the European Union. Those of you who are internet lawyers will definitely have great careers before them. And I would love to, at some point, meet with you again, I guess, and discuss this further. On this note, I feel that my time is up. Thanks once again to the Center for Civil Liberties and to American Bar Association Rule of Law Initiative for arranging this event. Thank you, Roman. Let's maybe take 5 minutes for further questions if we still have 5 minutes. It has been a pleasure speaking in front of you today.
Sure. Oleg, thank you for your excellent analysis, both at the beginning and during the case law examples. I would like to emphasize that at the beginning you mentioned not to mess up European Union Charter of Human Rights and the Convention on Human Rights. Mm-hmm. And with regard to this, I would like to say that my organization, Center for Civil Liberties, translated European Charter to Ukrainian language, because previously it was on the Verkhovna Rada website in Russian, and Russian translation is a little bit misleading, and its interpretation of human rights is rather short than Russian. And if our guests are university lecturers, you can share Ukrainian version with your students. Also, we will put the video recording on YouTube, and if your colleagues or your students will benefit from Article 10, I believe Oleg provides excellent analysis on the topic. Majority of questions were answered, were implemented into your presentation, but I have one more. How many Ukrainians applied to the European Court of Human Rights over the past year? Mr. Soldatov, how to assess a court statistic, for example, for 2022 in case of Ukraine?
Right. Look, I no longer work in the court and I don't have the internal statistics as recent as 2022, 2021. And as you remember, there are at least 90% of cases that are inadmissible, and they might be inadmissible on very, very different grounds. Some of them, they are not even taken into account when we compile our statistics. But from what I remember, around 4,000 cases were allocated to a judicial formation in 2020, which means that, well, they also include some backlog cases. But in general, it's more than 10,000 cases each year that come into the European Court of Human Rights from Ukraine. And again, the majority of them are then declared inadmissible. Some of them are allocated to judicial formation. And then the percentage of that is again declared inadmissible, but already by the judicial formation. We'll see how exactly the statistics will evolve in light of the current Russian invasion of Ukraine, because of course there are a lot of upcoming questions. At the same time, there is no working post offices in many territories of Ukraine right now. But I would say that in a year, we're talking of upwards maybe 10,000 of cases lodged by Ukrainian citizens against the state of Ukraine. Well, not even Ukrainian citizens, lodged against the state of Ukraine by citizens of various nationalities. In general, I think it's almost a tenth of all the applications before the European Court of Human Rights. Ukraine is one of the biggest respondent states in terms of the number of cases. Again, I don't want to give you incorrect information. What I found very recently on the statistics website is the number of cases allocated to judicial formation, but it doesn't mean the general number of cases that reach the court. The general number is around 10,000-ish, I would say. But then quite a lot of them are not allocated to judicial formation. And then from those that are allocated, quite a lot are still declared inadmissible.
Oleg, thank you. And I can emphasize that if you want to visit, if you want to have more precise information, you can also visit HUDOC website.
Oh, right. All of the cases that I've mentioned, they are all publicly available. All of them are public on the huge database, which is called HUDOC, HUDOC. Just Google that. And you will see not only all of the cases ever deliberated in front of the European Court of Human Rights, you will also see analysis, case law notes on the most important cases. You will also see press releases to them. You will also see connected communications to the government from the court. So HUDOC is a huge tool for all of you who want to undertake research into the case law of the European Court of Human Rights, of course.
And also the court on yearly basis provide a report in English and French about its activities. Just you can also, for academic purposes, you can also analyze the report. It's rather complicated, but with if you need to extract information, you will know how to do it. Okay, we have 2 minutes to go, and I will briefly say that Oleg, on behalf of the Center for Civil Liberties, we wish you a great success in your career for the state of Ukraine. And dear participants, see you next time. Stay tuned to our lectures. Thank you very much.
Thanks to everyone. And again, let's stay strong in these hard times.
Of course.